Good evening, everyone. My name is Erin Delaney. I'm the director of the Global Centre for Democratic Constitutionalism here at UCL, and delighted to be chairing this joyous celebration of what is an extraordinary piece of work. The Cambridge Handbook of Constitutional Theory brings together contributions from leading scholars, many are online and in the room, of constitutional theory with backgrounds in law, philosophy, and political science. It's 60 chapters. You get value for money here. 60 chapters offer an exceptional survey of the field, and they are themselves contributions to knowledge. The book covers values, modalities, institutions, and challenges, so it really does have something for everyone. Given the book's breadth and depth, this evening we are only going to be able to address a small portion of the rich content. So take one home and read it on your own time as well. But we will be able to have fantastic conversation because of the reflections of our terrific scholars that are weighing in on the panel tonight. So it's my great pleasure to introduce them to you. I will introduce each one and then each person, and then you'll speak, and then I'll introduce the next person just to, keep things lively. What we have is about 8 minutes. Each person will speak for about 8 minutes. Then the editors, who need no introduction, but who I will enjoy waxing rhapsodical about, as my colleagues at the center, will have an opportunity to respond. Then we will open the floor for questions, and for those of you online, hello, nice to see you. You can raise your hand and contribute as you see fit at that juncture, and we will call on you and bring you up onto the screen. So thank you all, everyone, very much. And without any further ado, we are off to the proverbial races. Our first speaker tonight is Leah Trueblood. She joined the University of Surrey just now and is a senior lecturer in law, after having been fellow and tutor in public law at Worcester College, Oxford, and a British Academy postdoctoral fellow at Bonavero. She researches how law can help to build resilient democracies. Her own terrific new book, little plug, Referendums as Representative Democracy, is out and ready to be read by all of us here, if you haven't done it already. The floor is yours.
Well, thank you so much, Erin, and it's a complete joy to be here tonight. So I have two small children. My sons are 3 and 1, so I read a lot of handbooks, and handbooks about sleeping and eating, and particularly how to play well with others. But these handbooks, I hasten to add that they're for me. They're not for my sons. But when Jeff and Richard very generously asked me here tonight, the first thought that came to my mind is, what is a handbook for? What might someone read a handbook? So 2 reasons came to mind why someone might pick up a handbook. The first is that they want to find inspiration or ideas to help them solve hard problems. And the second is how to make difficult choices between competing priorities. So tonight, I'm going to begin by saying what I liked about the book, and then I'll evaluate the handbook by these 2 criteria. I think the book succeeds clearly in satisfying both the reasons someone might pick up a handbook. But first, why this book is great. So I can't say this book is a contribution to the literature, because it is the literature. To the surprise of no one, given its editors and contributors, I can't claim to have read it all in depth. But the introduction in every single chapter that I looked at are meticulous, thorough, comprehensive, thoughtful, compelling, and grounded in the incredibly difficult questions that we face today. The book is a triumph. But turning to the ideas and the inspiration, it gave me the first reason to pick out a handbook. So what was fun about the book, reading it, was it raised ideas that I hadn't thought about, even on topics that I've been teaching and researching for a long time. And tonight I'll speak about just some of the connections that struck me in part 1, and then connect those to some of the discussion at the end on challenges in part 4. So in the first part, in Waldron's introductory chapter on dignity, I was struck on page 32 when he says, and I'm going to quote him, Dignity used to be deployed as a term for high office, the dignity of a king or the dignity of a judge. I found it useful to consider this hierarchical notion of dignity has not been abandoned, but in a sense reversed. We're now all possessed of high status dignity. That's what conceptions of dignity have to satisfy. And this was probably not news to any of you, but this flew off the page to me. And I'd never thought of dignity as an inversion that way. And I found it so beautiful and such a powerful way to begin the book. But I did think this inversion could help Waldron. So a couple pages earlier, it felt like he got wrapped around the axle. So he was uncomfortably trying to square the circle of how to avoid talk of dignity turning into moralizing in a way that might uphold, for example, sexual orthodoxy. And Waldron says, look, we shouldn't be too hasty in letting go of the moralizing pieces of dignity, because we might then lose what's undignified about the treatment of detainees, for example. And this all just seemed to me a completely unnecessary rabbit hole. Waldron, what was wrong about the treatment of detainees sometimes is what was captured by his account of inversion. Everyone has dignity. That means everyone. This is true of minorities of all kinds. And the question of moralizing, I just thought was a non-issue. I couldn't see why he was worried about it. So in the tremendously impressive second chapter on rights, Rowan-Cruft puts a question about rights in a way I'd never thought of before, but again, is probably not news to you. So he says on page 40 that a constitution that did not change need not have rights at all. A constitution that did not change did not have rights at all. He says a liberal democratic constitutions do require claim rights of voting and participation. But I thought his excellent chapter really connected to the next chapter on self-government, in which Thomas Cristiano really says the missing piece he thinks of the literature on self-government is the connection with access to information. So inequalities of power, he thinks, are principally driven by inequalities in access to information. And I thought this was really the missing piece of the Cruft piece, and thinking about what kinds of claim rights might be required by democracy. But while I thought Cristiano was asking the right question, I was a little bit worried about his answer. So his answer is more free, high quality access to information. And I just want to caution us that more information isn't necessarily better. And information, it really matters what kind of information in the project of self-government. So if I had a lot of information about the stock market, but I knew nothing about the lived experience of people in modern slavery, I don't think that would be enough for the project of self-government. So I think he's pointing us in the right direction, but the devil will be in the details. So I've not read all of the book, but I think what I have read succeeds in what Tom Poole calls on page 676, a project of applied constitutional history. And I think, cool, does mean here the book is doing three things. It's doing conceptual work, it's doing historical work in a way that has fidelity to experiences, recognizing that constitutions can change, and that's part of the point. But in reading the chapter on recognition by Helder de Schutter, I started thinking about this hard choices point. So de Schutter says, look, we should take a plural conception of recognition, and we should have what he calls an equal, I'm going to make sure I've got this right, an equal services approach to recognitionalism, for example, with respect to official languages. And I was totally persuaded by his argument, but I started thinking about hard choices given the limits on what states can do. And just so no one thinks I'm just picking on de Schutter, in Cruft's chapter, he says, look, what follows from his account is an extremely demanding conception of welfare rights. And this is going to bring me to the last part of my comments. So de Schutter is right, I think. Ideally, constitutions should have an equal services principle, but de Schutter isn't doing ideal theory, and I didn't read any of the chapters I read as ideal theory either. And this got me thinking about scarcity. And given the book is the literature, whether there's a gap here in thinking about scarcity substantively as a constitutional constraint or a topic for constitutional theory. And perhaps the most controversial thing I'll say tonight is I think even if it were an exercise in ideal theory, scarcity of some kinds would still be a consideration. And I thought this idea of scarcity really came out clearest in Jocelyn Stacey's chapter on climate change, where she doesn't say this, but it felt like an emergency was framed as a kind of scarcity. And I thought kinds of scarcity that might be interesting as the field moves are thinking about voters' attention, which was the point about self-government, natural resources, political will, moral imagination, and the brilliant Erin Delaney argued this in Oxford in the spring, time, that we didn't think about enough about time as constitutional theorists. And I thought she was completely right about this. So I just want to say again that the book is a complete triumph. And what I wanted to say, and with my most important point, is that all the handbooks for kids now say, well, we're not talking about sleep, we're doing a community of people worried about sleep. And this is a bit waffly sometimes. But in this book, it did read to me like a community building exercise. And it was inclusive in all the important ways of topics, of methodologies, of institutions, of people. And I thought when I left reading it, feeling really optimistic about the field. This is a group of people that are up to the hard task of solving hard problems. And even in a really tough period, it's a great place to be. So I'm really grateful to Richard and Jeff for the book and the opportunity to be here. Thank you so much.
Thank you.
Thank you, and beautifully timed. Speaking of time. Professor Alon Harel is up next, the Mizok Professor of Law at the Law Faculty at Hebrew University and a member of the Federman Center for the Study of Rationality. His areas of research include moral, political, and legal philosophy, criminal law, law and economics, human rights, and many other things that I could go on to discuss, including judicial review. So thank you very much for being here, and the floor is yours.
Yeah, thank you. Thank you very much for inviting me. I'm a newcomer. I still regard myself as a newcomer to the field of constitutional theory, although I've been doing it for about 10 years. And the reason I've been doing it is because it used to strike me that we don't need anything like this. And the reason we don't need anything like this is that the value of constitution is self-evident. Who needs it? Now, I think that these days, living in these days, these years, it goes without saying that this is not true anymore. And a deeper understanding of constitutionalism, which this unbelievably impressive volume can help foster, perhaps can strengthen the chances of survival of constitutionalism, which seems to collapse or to be in danger all over the world. So I think this is a good time, an excellent time to have such a volume and to think how it can contribute to reality, to the real life. Now, what I'll do here, I'll try to provide a new characterization of constitutionalism, which meets some of the criteria that are set by the editors. The introduction, fantastic in setting certain criteria as to how we should go about doing constitutional theory, and I'm going to try to honor this request and set a theory which will satisfy the criteria. The editors appreciate greatly the importance of conceptual constitutional theory, identifying concepts such as sovereignty, constituent powers, questions of this type. They also very highly regard what they call positive constitutional theory, which analyzes deep and fundamental features that are distinctive of particular legal system. Nevertheless, and this is of course being a student of Joseph Raz, who was my supervisor, that's obvious, they believe rightly in the priority of normative constitutionalism, namely identifying the values that animate constitutionalism. At the same time, the normativity they cherish is what I label here weak normativity. Namely, the values underlying constitution need not be ones that make constitution desirable. A theocratic or authoritarian constitution is as much a constitution as a liberal one and enlightened one. I wish to endorse this view, and I wish to argue that, or to try to find a way to justify the values underlying constitutionalism, which potentially can serve important purposes, but do not imply that the Constitution is correct. To do so, let me start with a very banal observation. Why is it so difficult to understand what constitutionalism is? Why is it more difficult than tort law, criminal law, questions of this type? The difficulty lies in the multiplicity of values and subject matter that are classified as constitutional. They include the governance, the institution of governance. They typically include human rights. They typically, in other jurisdictions, perhaps not in Britain, they include issues of national identity, national language, religion, a lot of things that do not seem to fit into one significant whole. Compiling such a broad range of issues under the label constitutional law make it particularly difficult to capture the essence of what constitutionalism is about, and may raise a suspicion that there is no essence there. There is nothing there. It's just a compilation of things that differ in one country. To address this concern, I think theorists develop three primary types of definition of constitutionalism. Some are based on formal or institutional features. So it's entrenched norm, supreme norm, codex, short document of the American type, and so on and so on. The editors justifiably reject this view and establish that constitution need not be written, codified, or entrenched. At times they consist of convention, unwritten norm, and so on and so on. So the forms and the institutional forms are different. Other characterizations are based on the subject matter. Here, I think the editor, unjustifiably, I think, are more sympathetic. They speak about governance, institutions, second level norms, Hartian secondary norms, and so on. So this is, to some extent, is a characterization that is endorsed in the introduction. Obviously, this is something that all constitutions have, but I doubt it could provide an understanding of what constitutional is. Last, there are value-based characterization, like the famous one adopted by Sartori, speaking about liberty, rule of law, and stuff like that. I wish to reject those and make instead a proposal which meets the criteria set by the editor for a good definition, namely what can be labeled weakly normative characterization, one which does not imply that the Constitution is good or desirable. To do so, let me mention two features that I think characterize all constitutions. First, the norms and values that Constitution contain are conventionally considered to be important, foundational, indispensable to the governance and life of the polity. This is the first thing. Second, and that's more important for my purposes, constitutions are typically very salient in the social life and political life of the polity. They play a prominent role. People know about them, discuss them. They are visible. And this, I think, explains also things like why constitutions contain values that engage the public. Liberty, freedom, autonomy, dignity, things that people can understand. They're not legalistic. These features, Constitution embodies those, what I want to say is that Constitution embodies those norms that we hold should be cherished by citizens, acknowledged as important, and regarded as central to the political community. Unlike ordinary laws, the value of constitutional norm may be realized only if it is publicly recognized, endorsed, acknowledged. Let me provide a kind of formal definition. There are norms and values that are particularly important. At times, they are not only important, but it is also particularly important to highlight their importance, to amplify their salience, to bring their prominence to the forefront of public life. Constitutions contain those norms and values that need to be publicly recognized as prominent. They need to be ones that people understand, care about. Hence, the motto I use to describe this characterization in a manuscript I'm currently writing, I took it from someone, on the importance of being recognized as important. This account explains why constitutional law is perhaps the least technical field of law, one that suffers to its moral concept. I believe this characterization explains at least three different fields that are typically covered by constitution. One is the governance. And the reason people should care about governance is because they are participant in the governance. Yeah, that's the first one. Secondly, rights. And rights become important, especially autonomy-based rights. They become important and valuable when individuals care about them and exercise them. Rights that are on paper do not matter. Autonomy-based rights are one that we should exercise, understand their importance, know that we have them, and exercise them. Last, national narrative and symbols are not meant to be mere inscription on paper. They are meant to evoke a sense of national pride and unity. They are meant to engage the people. To sum up, it's ultimately the recognition and endorsement on the part of citizens that are necessary for the goods provided by constitutional norms to be realized. The most fundamental concern of the public constitution is to mark certain norms and values as important. Constitutions, therefore, need not zero? Okay. So I will, I said most of what I wanted to say. I'll just say one sentence. To successfully do so, the Constitution must stress the prominence of the norms and the values it contains. The most fundamental concern of the public constitution is to mark certain norms and values as important, to make them salient, to amplify their presence in the public sphere and enhance their visibility. Thank you.
Thank you, and I look forward to the conversation about that with the book editors. But now we have Dr. Carmen Pavel, is a reader at King's College London, and prior to her time at King's, she was a fellow and lecturer at the University of Virginia. She's a political philosopher. She has interest in the intersection between politics and law, as well as the history of political thought. And the floor is yours, so thank you very much.
Thank you so much, Erin and the Global Centre for Democratic Constitutionalism for hosting this event. I will start by talking about science fiction. Okay? So I find puzzling that contemporary science fiction portrays a very limited repertoire of political orders that are very different and distant from liberal democratic ones. In Dune, the main political options are either a tyrannical and corrupt leader of the House of Harkonnen, or the charismatic heir of the House of Atreides, who's anointed as a religious prophet by performing certain feats of courage and magic tricks. There is often little sense that in the distant past, namely our time, the Earth possesses a constitutional history of at least 200 years, which offers practical and theoretical resources that could inform political choices in these worlds. Science fiction thus fails to inspire a political imagination by neglecting this history and the theoretical resources that have sustained it. But we should acknowledge and celebrate that successful and progressive history that we are part of today. While much work still remains, liberal democracies have accomplished wonderful, amazing things. They have extended political rights to women and minorities, including rights of access to education, professions, and political office, have reduced the incidence of racial and religious discrimination, have protected individual dignity and freedom, have expanded the welfare state, have developed institutions which embody the principles of separation of powers, the independence of judiciary, due process, and equality before the law. These are all well known. And much of this historical wisdom is collected in this volume. Annabelle Lever and Philip Pettit discuss equality and liberty, Nadia Urbinati, political representation, Jeff, the rule of law, Cecile Laborde, secularism, Nick Barber, constitutional entrenchment, Karen Levy, emergency powers, Christine Lanford, constitutional courts, Richard, bills of rights, Turkler, Isiskill, the constitutional implication of regional integration. This book is so heavy with wisdom, in fact, that it's literally groundbreaking, not just metaphorically speaking. Nonetheless, we find ourselves in a strange political moment that feels more like science fiction than reality, and not in a good way. It is a time of profound political and economic uncertainty, of rejection of core principles of international law, and regressive domestic politics. We see political leaders denouncing the principles of constitutional government and acting covertly or overtly to undermine them. Covertly, they might play constitutional hardball, as Tashnit in this volume termed a strategy of using constitutional process to undermine constitutional principles and institutions. Overtly, they might take a wrecking ball to constitutional orders and luxuriate in the ensuing chaos. Increasingly, democratic elections empower and enable those who deploy nationalist and populist rhetoric and have authoritarian ambitions. So, informed by this collection of essays, I see three possible responses to this problem. First, we must resolve what I call liberal democracy's massive PR problem. We must engage in defending the central values and principles that animate liberal democracies, because as we can tell, whether it's fascist or nationalist ideology or some version of left-wing populism, citizens are told that whatever economic and political obstacles they face these are the result of liberal democratic institutions. The historical knowledge of the evil of most of the political alternatives to liberal democracy feels lost to the generations that face new problems in a world that has much changed since liberal democratic ideals were first articulated in the 17th and 18th century. So we must engage in a robust defense of the values and principles of democratic constitutional orders with arguments that are suited to the social and political and economic challenges of our time. The lack of economic opportunities in a world that requires increasing levels of costly training and specialization, social isolation and alienation, and technologies that both facilitate our work as well as replace it, and usher in unprecedented levels of social monitoring and sanctioning, to name just a few. I take the point that Richard and Jeff make in the introduction that despite disagreements of how constitutional values and principles are to be understood and implemented, there's wide scholarly agreement that they are fundamental to any decent political order. So like Leah, I'm optimistic about this convergence because it is remarkable in fields or subfields that actually have an internal logic of disagreement. So we should build on this and renew the case for liberal democracy's constitutional values. And we actually must start doing this in universities where it is fashionable for some academics to dismiss wholesale the wisdom embodied in constitutional practice and thought over the last 2 centuries. And of course, we must not stop at universities. As political and constitutional theorists, we must embrace our role as democratic under-laborers. According to Adam Swift and Stuart White, who coined this term, this role consists in participating in public debates and evaluating the practices of political institutions and proposing reforms in line with our expertise without claiming a privileged position as a decision maker in this regard. Second, we must attend afresh to the design of constitutional institutions, many of which are buckling under pressure and are no longer able to serve their constitutional role. I salute the inclusion in this volume of a good number of chapters specifically devoted to institutions. The themes related to institutional design permeate all chapters. No institutional setup, no constitutional setup is perfect or immune to the coordinated attacks of ill-motivated and self-serving political elites. But marginal improvements in the designs and functions and procedures of our institutions are possible and can make a big difference. Institutions can be more or less resilient to such attacks. And we can collect wisdom from a comparative study of existing constitutional orders about what works and what does not. So Christian Lanfried, for example, recognizes the limitation of constitutional court, just to take one example, but takes these limitations not as a reason to abandon, but to look for successful examples of courts improving the rationality of democratic decision-making through the practice of holding political power accountable. Thus, a very politicized US Supreme Court might learn from the appointment and operational procedures of the German Constitutional Court, even though they operate on the basis of different constitutional rules. And finally, and particularly in light of the simultaneous erosion of global norms and institutions, we must review the domestic constitutional basis on which states engage with each other in international politics and potentially amend those rules that stand in the way of successful and joint governance of global problems. Nationalist discourses that sanctify absolutist conceptions of national sovereignty are no longer fit for a world in which many problems span national borders and which cannot be addressed by states acting unilaterally. Constitutional language can be valuable as an ethos, disposition, and set of practices at the international level as well, although they would have to be reinterpreted and adapted for that very different political and legal context. Universal respect for human life and human dignity, deference to the practices of collective self-determination of others, and a commitment to finding collective solutions to problems that affect us all, such as climate change, must inform democratic conversations about national constitutional rules and their impact on international legal cooperation. So to conclude, we need both constitutional theory and science fiction that is inspiring, that are inspiring, and can inform our choices for the current political moment. And if you want to find out more about how to formulate such a theory and tackle the challenges that I mentioned above, I recommend that you turn to this book.
Thank you very much, and it's nice to find moments of optimism, so thank you. And our final commentator tonight, Dr. Udit Bhatia, a lecturer in political theory at King's College London, whose work focuses on normative democratic theory, constitutionalism, and political epistemology. He's published fascinating work on political parties and party democracy, and the floor is yours for our final comment.
Okay, thank you. Right, so I have to say, I felt a hint of imposter syndrome when I was asked to comment on the handbook, and that's because I don't ordinarily self-identify as a constitutional theorist, but then I found a lot of reassurance in Jeff and Richard's introductory chapter. Because in that chapter, they describe normative constitutional theory as a branch of applied political theory. So thank goodness I'm not in the wrong book club. They say it's a branch of applied political theory that pays closer attention to constitutional institutional detail. That's what makes it constitutional. But it's also a branch of applied political theory that typically aspires to transcend particular political orders, and that's what makes it theory. And I think that's right, but I think it's worth clarifying that there are two senses in which theory of this kind can transcend particular political orders. Now, the first way in which it does this is by addressing questions that most constitutional democracies share, questions like bicameralism, or campaign finance reform, or judicial review, questions that feel familiar because they presuppose what we treat as normal constitutional baselines: functioning legislatures, enforceable law, threats of private wealth to elections. But then there's a second way in which theory can transcend particular political orders. It can do that by addressing questions that emerge under more limited but recurring constraints, constraints that aren't universal, but aren't idiosyncratic either. They keep coming up across families of constitutional orders marked by weak parties, weak rule of law, or entrenched patronage. And if we don't recognize the second form, we fail to even see a whole terrain of normative questions. And I'll give you a couple of examples. Firstly, India's anti-defection law. So the Constitution mandates party discipline on pain of parliamentary expulsion. So legislators who vote against the party will stand to lose their seats in parliament. A handful of countries have similar provisions, and these rules raise important questions of principle: the role of the party in the Constitution, the relationship between party and parliament, and indeed the nature of representation itself. But these provisions also raise important contextual questions. How should we secure the integrity of party politics in circumstances of weak party institutionalization? How do we prevent legislative capture when there's weak rule of law? A second example, anti-dynasty provisions. So for example, Section 26 of the Philippines Constitution prohibits political dynasties. And again, there are similar provisions in a handful of Latin American countries, and these provisions raise fundamental normative questions, questions about the right to stand for office, about democratic competition, but they also raise more contextual questions. What do we do about entrenched patronage, state capture, and weak campaign finance enforcement? So what counts as a theoretical question partly depends on the baseline that we assume. So debates about bicameralism, for example, seem pretty normal because we take for granted that legislatures exist and that they could be divided between two houses. Questions about campaign finance feel ordinary constitutional theory because we assume that private wealth exists and that private wealth could distort democratic elections. But other conditions, whether the state can enforce basic rule of law, whether parties are minimally institutionalized, or whether political participation extends beyond entrenched families, often fall outside our imagined baseline. And yet these are ordinary conditions for much of the world. So if our theoretical map is drawn around high capacity democracies, these questions about anti-defection clauses or anti-dynasty provisions start to look a bit eccentric, even though they emerge across a range of constitutional orders. In other words, I agree with Jeff and Richard. I agree with their approach to normative constitutional theory. But I think it's worth distinguishing these two senses of theoretical work. precisely because the second of these senses is often neglected by those of us who work on constitutional law and politics. And I think it's a virtue of their handbook that these non-ideal circumstances, challenges, and contextual constitutional questions are so prominently represented. But I have a second point to make, which is an important tension that the handbook reveals, and you find this across various chapters in the handbook, and that's a tension between incremental constitutional adjustment, and my colleague Carmen referred to it as marginal improvement, a tension between that kind of marginal improvement and radical constitutional reimagination. So some of the chapters, for example, urge us to focus on the finer details of constitutional rules around democracy or legislative design or the role of the opposition. So Daniel Weinstock, for example, in his fascinating chapter, calls for normative attention to the micro-circuitry of elections. But others, like my colleague Stephen Klein, retrieve forgotten ideals like corporatism. They retrieve these forgotten ideals to reimagine democracy in the face of concentrated power and hollowed out formal democracy, as Klein puts it. And I think these are very different projects. One tries to tweak the edges of the Constitution, chipping away at more or less prominent pillars of existing constitutions. The other tries to rethink constitutions in a more radical way by calling for more radical change in the face of forgotten ideals. Now, which path should normative constitutional theory take? And I think that would partly depend on our diagnosis of democracy's crisis. Now, Nimer Sultani's chapter offers a really stark diagnosis. I'm going to quote Sultani here, who says, the legitimacy, stability, and durability of constitutional order, even in liberal democratic states, are neither secure nor settled. Counter-majoritarian structures continue to deny the many the ability to rule, and wealth distributions privilege the few at the expense of the many. Capitalist political economy widens social inequalities, perpetuates poverty, and ruthlessly exploits nature for private profit. It thereby foments social unrest and endangers human survival. End of quote. Now, if this is our diagnosis of democracy, how do we decide between small c change and radical constitutional transformation? And I think deciding between these options means answering three questions. Firstly, how deep are these problems? Are they contingent flaws or structural features of democracy as it exists today? Secondly, what is the risk of major constitutional transformation, and how much risk should we be willing to accept? And finally, how bad is the status quo? And how much worse could radical change make it? And Jonathan White and Leah Yippie's chapter offers us some advice on how they might deal with these questions. So they argue that moderation may be an appropriate ideal in a nearly just society, but things look different if the status quo itself is corrupted and plausibly in need of far-reaching change. End of quote. If this is our world, then normative constitutional theory, at least according to White and Yippie, cannot remain confined to the micro-circuitry of elections. It needs to move closer to philosophy, to the speculative work of imagining institutions that do not yet exist, and closer to history by treating neglected constitutional projects as resources for democratic renewal. So thank you, Jeff and Richard, and the contributors of this volume for advancing our ability to address these vital questions.
Thank you.
The call to arms for history, philosophy, politics, law, economics. It truly is, as I like to say, an all hands on deck moment for the world. We now turn to the editors who really need no introduction to this group, but it is my great pleasure to introduce Professor Richard Bellamy, Professor of Politics here at UCL, research ranging from historical studies of Italian political thought all the way to what's happening in Westminster, tomorrow. So thank you, Richard, for being here. And Jeff, my colleague here, professor of law at UCL not only the creator in many ways of the Global Center for Democratic Constitutionalism, but a great scholar of the rule of law. And together we have politics and law bringing together for this tremendous volume. Which of you would like to respond first?
Go ahead. Okay.
Richard.
So thank you so much for these stimulating and excellent comments, to which I feel I can't do justice. It's 2 minutes each. So first to Leah and the issue of scarcity. I mean, so my thought on that is that I mean, Hume regarded the circumstances of justice as originating from scarcity and limited altruism on the part of people. And one can say, likewise, the circumstances of constitutionalism derive precisely from that element, which as I don't see going away as a problem to address. But maybe you're right that it's, and I'll come back to this, it's a problem that we should have addressed more than we do. It's sort of implied, but not always there. And then to Alon on the importance of constitution being, I think Raz in his discussion of the constitution talks about the importance of it being people's law, not lawyers' law. And in a way, I guess that's perhaps what you're getting at. And there, I mean, I absolutely agree with you. And one can back, but it also, and this links to the issue raised before, think of the United States. Surely in no other country is the Constitution put forward as all important and something that the people themselves should have, it's their product. This is what the official doctrine is. And yet it's being destroyed in every sort of sense now. And that just shows that why it is important that it's seen that way, but how fragile that can be. And then, so why is it fragile, and how might one deal with that? So, you know, Carmen has this wonderful sort of call to arms for us to move in this direction. But I think part of the problem lies, I don't think it lies inherently with liberal democratic political values. I think it lies in part with what I think of, though it's not technically, I think one of the chapters that both Jeff and I sort of said, this is different to what we thought, was the chapter on the material constitution, where, you know, the author quite rightly talked about it as it's come to be conceived, whereas I had a more kind of Marxian thought anyway, as to that it would be the substructure underlying the superstructure, as it were. And I think in part we have neglected that, because why is it that one has widespread dissatisfaction with current politics? Well, because it seemed to be caught in a form of economy which is failing to answer the scarcity problem for so many people, and we don't tend to think of that as a constitutional issue per se, but it is in a sense. The economic constitution is vital, and again that possibly that is a lacuna in how we thought about it, but one which is pretty vital for addressing the problems that we now face. And then and I think all of these do neatly fit together the comments that people have to Udit's reflections, and one of them is, you know, is about how far the constitutional principles need to be adapted to particular contexts and contingencies. And in one of the chapters of my sort of forthcoming book on political constitutionalism, I sort of say that one needs to think of the principles maybe as universal, but as requiring different instantiations in different sorts of contexts. So I agree with that. I also think that it's important not to fetishize particularly certain kind of institutions, but this is the only way to realize a certain constitutional value is through a particular way of thinking about it, but you know, the separation of powers and seen in some kind of canonical way, which if you don't have it, you don't have constitutionalism, and I don't think that is necessarily the case. As to the reform or revolution, I mean, things are pretty bad. I still am somebody who perhaps favors incremental change over revolution, but I'm also all too aware that we may be forced into a position where that isn't an option anymore. So thank you so much. And I should say, I also want to thank Jeff for the collaboration during this. This was very much a lockdown project in a way, because it was the publication was delayed by at least a year by things beyond either the authors or the editor's control. CUP was hacked, and that basically brought all the publishing of books to a halt. But yeah, under lockdown, a bright moment of it was almost the weekly meetings I had with Jeff, often at lunchtime, when he always had this amazing lunch provided
himself.
But I was very jealous of the lunch. But there was intellectual food that we partook of, discussing all of the chapters. And I really don't think it would have been possible outside lockdown to have done it. But I am yeah, very grateful for the experience. It was,
Thank you, Richard. So I wanted to take a few minutes to say a word about the book, the commentators, and about Richard as well. So the book is, as you've seen, it's incredibly ambitious. Why not? It has to be said that there are Cambridge and Oxford handbooks on some topics that constitute one chapter of this book. So why did we go so broad? Well, it's in part because we think that there's something of value in seeing the linkages between different areas of constitutional theory and institutions, and with each of these being explored with exceptional competence. So as I think we both see it, the book is partly a topography of constitutional theory. And we see something pedagogically valuable in the way, and if you're just looking at the table of contents, to think of different principles and institutions and how they can trigger your thinking about the relevance of those principles and institutions. For instance, part 3 on institutions contains 7 chapters on the facets of the state, 4 on the executive, and 7 on the institutions of democratic systems. And there are another 2 subcategories in there as well. And we're hoping that can provoke people to see some of these links that we consider important. let me turn to the commentators. So I'll go roughly in order. I'll change it just a bit because of the thematic similarities between some of the comments. So Leah, I'm beyond grateful you found time to look at so much of this book while juggling two toddlers, one of them only just. So your comments picked up on the book's merits across diverse criteria, and I wanted to focus in my response on the question of whether the handbook facilitates hard choices. And the tough question you pose here, and which surfaces in Udit's comments, is whether the problem of scarcity receives its just due in the volume. Now, I think scarcity is crucially important. My focus intellectually has been on social welfare rights and more recently on states of emergency. So how could I not think that? And I think my reaction was not dissimilar to Richard's, even in the high priest of ideal theory and political theory, John Rawls, incorporated considerations of scarcity into the circumstances of justice, just as Waldron does when he talks about the circumstances of politics, and not just scarcity of economic resources, but limited altruism and things like this. Now, my sense is, to come to the provocation more directly, is that in good constitutional theory, the recognition of these kinds of limits is often implicit in the analysis. It certainly is among lawyers for whom these considerations are never far from the discussion. So where scarcity is acute, as in emergencies and in social welfare rights, scarcity comes directly into the discussion. It's explicit there. Now, I think Udit's related considerations actually are not addressed by what I just said, because I think the really difficult thing in what you'd said, Udit, is that the imagined baselines, I think is a term from your talk, that we've chosen foreground real-world institutions in what you call high-capacity democracies. So the implicit understanding of the problems of scarcity, limited altruism are implicitly framed upon how these institutions tend to work in more wealthy constitutional orders. Now, I'm not sure that there is much left in the area of high-capacity democracies anymore. And I do think you're probably right that the method has a blind spot here. But I do have two considerations by way of reply. I wonder, I mean, and the overarching concern here is, can you really have a political theory of the second best for non-consolidated democracies? First, because a lot of the considerations that relate to how you can achieve democratic legitimacy or respect for the rule of law will relate in those polities to strategic and instrumental considerations, right, rather than deep theoretical ones, I believe. Like, how do we do that in this particular polity? And secondly, and I think more importantly, is that the answer to those kinds of questions will probably vary radically between different types of such non-consolidated democracies. And so it's a worry I have. I think, and I'm not denying these issues. I did a conference on constitutionalism in Africa when I realized a lot of the debate we were having about legitimacy of JR had no application whatsoever in those places. No offense, Richard. So those are some preliminary thoughts. So Alon rewards our inquiry by delivering an entirely new constitutional theory about the character of durable constitutional theory. And your emphasis is on norms and values that are particularly important. And you think that it's crucial in a constitutional system to amplify their salience in the polity by bringing their recognition to the forefront of public life. Now, I agree with what Alon says about the importance of constitutions being recognized. And I'll look forward to his seminar on his manuscript coming, I think, not so long from now at UCL. But I want to draw attention to a distinction that I think was not reflected as sharply in your comments as I think it was in our introductory chapter. We distinguish between the definition of a constitution from the idea of constitutionalism. And the Constitution is a juristic and political construct that any complex polity must have, and we have a normative way of defining that. Constitutionalism is an ism. It's a theory with a moderate normative inflection about how institutions should be arranged. And the reason we opt for our version is we think that there are socialist conceptions, neoliberal, transformative, but each is at heart a thesis about how to arrange those institutions, not about what constitutes those core norms that constitute a constitution. So on the question of public recognition, there is quite a bit to say. I think, and I think Richard has drawn attention to this, that there is a risk that forcing citizenry to consider the language of rights, and perhaps others like sovereignty, constituent power, could actually bring to the fore myths and misconceptions that more seasoned constitutional operators like public officials and parties are more likely not to adopt because they see the very dangerous aspects of those. So in this country, the popular understanding of human rights is shaped more by the Daily Mail than it is by Ronald Dworkin, I hate to say. And it poses a difficult problem. And that brings me around to Carmen's discussion about the importance of values that are covered in this book and what some of our tasks are as theorists and lawyers and philosophers. And you argue that we should be playing a more proactive role as defenders of these ideas. We should see this as our collective professional responsibility. This I agree with. And also you say that the arguments need to be suitable to the environment that we now are in. And this raises, I think, a fundamentally difficult question, because the environment we're now in is not so good with truth. And when you want to focus on arguments that are designed to refute what the other side is saying, you will often find that those arguments are not instrumentally effective at securing and shoring up the values that we think are really important. That raises profound difficulties for how people should view their role as a public intellectual, if that's the kind of thing they're aiming at. Whether we have to consider strategic methods that we would have thought were dirty hands before, I don't know, but there are questions here, and it's difficult to just try to refute falsehood when the technique doesn't seem to work as a matter for shoring up democracy. And the other thing I wanted to mention is that your discussion of internationalism, I think, is absolutely crucial. I do think that the subject is still too focused on states, like Rawls's theory of justice was, and that looking at the role of states, and not only under the banner of cosmopolitan constitutionalism, where borders might become morally irrelevant, but rather the more complex questions of states operating internationally, how that should work. I like, for instance, the debate on constitutional identity in Europe. These are really a great frontier, and we tried to bring some of it in, but I know your work does a better job of it. So lastly, Richard, so I've always seen Richard's work as that of a genuine constitutionalist. I think a lot of lawyers think of Richard as kind of an enemy of constitutionalism, and I've always known that that is false. I think temperamentally and intellectually, he wants to defend constitutionalism, and that's why, even though we have quite different views on judicial review, not as different as perhaps they once were, we've always had common ground in seeing this as incredibly valuable. I also, Richard, want to say that you're very open-minded, fair, practical, and the consummation of a collegial colleague. Thank you.